Hi, everyone. Thank you for being with us today. My name is Sharif Al-Khoury. I'm here with my colleague, Antoine Métayer. We are employment lawyers at Stikeman. Uh, I must begin by saying it feels good to talk about something other than COVID in employment law because every talk we've had in the past 2 years was about COVID. This time we're talking about something else. Uh, Antoine and I want to approach two topics with you. First, we want to discuss a bit the issue of workplace investigation. Uh, the the topic is a current one. It's something we see more and more of, especially as we see proliferation of best practices, recent trends, issues. And the approach will be to look at a few recent cases, but not from the perspective of summarizing each and every line of the case, but more from a general perspective of trying to delve into those cases to understand what are the fundamental issues that are facing employers when it comes to workplace investigations. Antoine will then speak to you about terminations of employment. He will address terminations of employment for cause. Why? Because, it flows well with the investigations, because many times the outcome of investigations can be termination of employment for cause. But he will also address termination of employment without cause, because in the current market and the economy we have, it wouldn't be unexpected to see restructurings in force, reductions, redundancies, etc. And so Antoine will look at the key considerations to keep in mind when conducting terminations of employment on a without cause basis. Our presentation will last for roughly an hour. We'll have a question period at the end of the talk. For those following remotely, below the video player right now, we'll find a tab that says Poser une question. Please use the tab to communicate with us. There's a delay of about 10 seconds between our live presentation and what you see on your screen. So we suggest that you ask your questions as soon as possible, and we will address them at the very end of our presentation. Our talk is English. Create a question for a name. For those with us in the room, there's a question period at the end. As I said, you can raise your hand and the mic will be given to you just to ensure that anybody following remotely hears your question as well. So let's get right into it with our first topic, workplace investigations. Workplace investigations are not new. They've been around for a while now. They were initially more common, obviously, in cases of financial misconduct, but they became a staple of every workplace with the enactment of anti-harassment statutes across jurisdictions. And harassment remains a real problem today. And so we are looking at the issue of workplace investigations through the prism of harassment. When I say harassment remains a live issue today, one of the most recent statistics on the topic in 2021, in August 2021, StatCan published a survey based on data that it gathered over a 1 year period in 2020. It found the following. 1 in 4 women, 25% Canadian workers, female Canadian workers, 1 in 6 men, 17%, reported having personally experienced inappropriate sexualized behavior in their workplace. And when we talk about people who experienced or witnessed, 47%. So nearly half of Canadian workers have either been the victim of or have witnessed sexualized behavior in the workplace. There are some other interesting findings in that study. Behaviors related to the display of sexually explicit materials often occurred by phone or online. We can understand how COVID can have an impact. Some people may have had the perception that COVID and remote work may reduce the frequency or impact of harassment. That is not necessarily true. In fact, almost 1/4 of workers, and this is right before COVID, 1/4 of workers who experienced inappropriate sexualized behavior said that it happened online. And a significant portion, we're talking about somewhere between 28 to 30%, women and men alike, said that they suffered the harassment by a person in authority, such as supervisor or a boss. Finally, although we have harassment laws across Canada, 32% of women, 26% of men said that their employer had not provided them with information on how to report sexual harassment and sexual assault. So this is quite telling. It shows us that harassment is still a live issue. It still exists very much so. But that's not necessarily for a lack of attempts by legislators to remedy the issue. We do have harassment laws in Canada. In Quebec, for example, we have protections under the Charter of Human Rights and Freedom, which prohibits harassment based on discriminatory grounds, prohibited grounds of discrimination. We also have the Act Respecting Labor Standards, which imposes a dual obligation on employers. One, prevent harassment. Two, remedy harassment if it arises. This also means adopting policies to address harassment, both psychological harassment and sexual harassment. Perhaps it may be useful to briefly review the definition of harassment. So when we're talking about psychological harassment, this is vexatious behavior that's repeated or sufficiently serious. If you may know that already, harassment can result from one instance, one event, or it can result from a series of events where each event taken in isolation is maybe trivial. But the pattern that emerges from these events over time would constitute. In order to be harassment, conduct also has to be hostile or unwanted. It has to affect the dignity or integrity of an employee and create a harmful work environment. Discriminatory harassment is essentially psychological harassment with a twist. So it's harassment where the harassment is based on prohibited grounds of discrimination. Sexual harassment also has a similar test with similar concept. The one distinction is that in sexual harassment analysis, there is particular emphasis that would be placed on the relationship of authority or subordination that may exist between two individuals. So this is what harassment. In that context, workplace investigations are a tool to address potential harassment, to address complaints and remedy them. The law in Quebec, and we'll get to it, but the law in Quebec was established on the fact that employers don't have an obligation of procedural fairness. So you can adopt policy, but there was a lot of flexibility for employers. However, what we've seen in recent years, we've seen a development in three parts. One, there are a lot more best practices, certifications, associations dealing with investigations. So that expands the tool of resources available, and it also expands the potential areas of risk. We've also seen companies develop internal investigation expertise, whether through having HR conduct investigations, having their legal departments conduct investigations, or having subject matter experts conduct investigations. So even we see clients who have now investigation departments. And in conjunction with that, we see detailed and sophisticated policies dealing with harassment. The policies that used to be 2 paragraphs long are now maybe 15 pages long. And with that, there are some pitfalls and some risks. So first, what is the current state of the law in Quebec? In 2014 and 2015, there were a series of 2 decisions of the Court of Appeal. And the first of them was Ditomen versus Boulanger. It was a Cégep professor who was dismissed following an investigation that determined that he had engaged in psychological harassment. He sued the external investigator, saying that the investigator was the cause of the dismissal. He was contesting a few things, but among other things, the diligence of the investigation, the speed of the investigation, the summary nature of the investigation report. And the Court of Appeal basically said that the employer's policy said that an investigation report should be brief, and it was brief. And at the end of the day, an investigation is only an application, an exercise by an employer of their management rights. And that means that it's not subject to the same duties that would apply, the duties of procedural fairness that would apply to, for example, an administrative body, a professional order, etc. 2015, the Court of Appeal reiterated that position. So the law is pretty clear. You do not have the same obligations as an employer that a court would have, that a tribunal would have, that an investigative body that's a quasi-judiciary would have. However, you are free to adopt policies. And what you put in your policies will bind you as an employer. And that's why the balanced approach is needed. There can be too much of a good thing. And when it comes to harassment policies, there's often too much of a good thing. Finally, the law is the law, but I mean, until it isn't. And the more we see best practices, the higher the risk of tribunals starting to consider those best practices in evaluating not only policies, but not only harassment investigations, but also policies themselves in the future. When it comes to best practices, to certifications, we see there are now a host of international organizations for investigators, but even if we look in Quebec only, in the past 5-6 years, what we've seen is the Order of Human Resources Professionals issued a best practices guide for investigators. And the Quebec Bar issued a best practices guide for investigators. The Human Resources Order, the Order of Human Resources Professional, issued a certification process for investigators. And maybe 2 years ago, the Quebec Bar also started the same certification process. I went through the Quebec Bar's certification process last year, and this is not a 1-hour conference. It's a 40-hour seminar over a 1-week period. And so from these best practices, from these guidelines, from the structuring and professionalization and development of investigative work, we see a few recent trends. Obviously, there are some rules that have always been true and continue to be true, but there are some recent developments. And I know a few. For example, looking at the best practices of the CRHA order, the presence of third parties is something that is more frequently addressed now in policies and in best practices. So employees in the past have employees who would ask you to have a lawyer with them, but that would happen rarely. But now the idea of having a friend, a colleague, somebody else present just for emotional support is more common. And it is something that can be addressed in a policy as opposed to be left to the discretion of the investigator, who would then have to make a bunch of decisions that all may feed into the evaluation of the credibility of the investigation. Another recent trend we see is the admissibility analysis. When you get an investigation, a complaint of harassment, sometimes complaints, even taken on their face, even taking all the facts for granted that are alleged in the complaint may still be frivolous, unfounded. And in that case, if the complaint is unfounded on the basis of its own facts, so even the facts taken for true do not constitute harassment, then the complaint can be deemed inadmissible. So it comes to a two-step process. This was something that was always done, but it's something that's becoming much more systemic and expected to be done in a systemic fashion. Another recent trend, for a long period of time, we heard that when you want an investigation, you need two people to investigate. We'll take notes, the notes of one will corroborate the perspective of the other, and that will avoid scenarios of person saying, no, I never told the investigator that. We also saw another tool aimed at the same objective was recording. We'd have a lot of recording of investigations. Etc. We see now that these tools are used less and less in some contexts, except where necessary, and declarations have become more of a systematic way to ensure that the version of the event is undisputed. So whenever an investigator meets a witness or for a person involved in a complaint. After the interview, they would draft a summary of their declaration, and the person would sign the declaration, and that gives this a fact from which you can start. It avoids the he said, she said scenarios. And obviously, documentation remains key, and we see more and more documents in investigation. And there's this idea probably that the validity, the credibility of an investigation seems to be proportionally related to the number of documents it produces. Mandates have to be well drafted, notices of the investigation, an analysis of admissibility, and a report on admissibility must have your confidentiality undertakings. The person being met to be confronted with the allegations, do they get in advance a written statement, a written summary of the allegations, etc.? What would the investigation report look like? The level of documentation involved in psychological harassment analysis, in my view, has increased dramatically over the last few years as the process becomes more and more structured, professionalized. At the same time, an investigation has to be flexible to a certain measure. So what courts have done is courts have acknowledged the importance of policies and that employers will be held to account for their policies. Now, at the same time, not every breach of a policy is fatal, provided that the investigation is otherwise fair and reasonable. And we've chosen a 2021 case that illustrates that tension that can exist. So this is a case about a university student who filed a complaint against her professor. Um, Essentially, the student used profanity, and the professor responded in kind. And at some point, the professor told the student, "You do not belong in a lab." An investigation was done. The investigation concluded that the statements of the professor were inappropriate. They were not it was conduct on becoming of a professor, but it was not psychological harassment. The professor still filed a grievance, and the grievance filed by the union was really about the disproportionate and inappropriate nature of the disciplinary action that was taken, but also about the whole process, the investigation, and how the investigation was conducted. And what's important to note is that the policy in this case is a very generous policy. It includes a lot of obligations. For example, once somebody files a complaint, two forms are handed to them. One form is called the complaint form, the other is called the administrative form. Each form has a section called description of facts, but only one form is given to the person accused by harassment. So when the employee received both and only filled a section in one form, which would have been the exact same one they should have put in the other, the position of the employer was, well, that's the wrong form. That's not a form I need to give you, the person accused, so I'm not going to give it to you, even though the content would have been the exact same. So it was a very formalistic policy. Even explaining it now, I still have difficulty following the number of forms and the process. So there were debates about whether the right form was communicated. The second issue, the policy had what is fair and reasonable in the abstract, but what is not often indicated in policy. The policy specified that witnesses may only be interviewed on facts relevant to the case, and they may not be interviewed as character witnesses. And the union was alleging that looking at the interviews, there were like 4 interviews that were with individuals who didn't have a specific, who were not specific witnesses to the event, so they did not have firsthand knowledge. And the union said that the only possible interpretation for meeting these people was that this was an exercise in interviewing character witnesses, and it's not bearing on aspects relevant to the case. Finally, the investigation policy had a 45-day time limit for investigation. Anyone who deals with lawyers knows the importance of delays sometimes in the system. And 45 days can sound very reasonable for some investigation, a lot less when you're meeting 18 or 20 witnesses. So in this case, they busted the deadline by a bit. It took 128 days instead of 45. But there were extensions that were requested internally by the investigator. The time limit was justified. The time limit, the duration was justified by the scope of the interview. There were 18 meetings, and the delays were not all attributable to the investigators. Some were a function of the person accused, but also the deadline was rarely respected. So it's a policy that's there that does not reflect reality. So looking at all of this, what did the tribunal decide? On the issue of the form and the description of the facts, the tribunal said, yes, the employer breached their policy. But the investigator was reasonable and fair enough in the approach where the investigator said, look, you're not going to get a copy of the form, but here, I'm going to draft for you a summary of the allegations against you. And you can review those, and those will allow you to ensure that your version of events is heard. And the tribunal found that that action by the arbitrator remedied the flaw of not following the policy. Same thing with character witnesses. Looking at it all, the tribunal found that it's not clear that this was exclusively about character witnesses and that the investigator was reasonable in determining that they should meet those people and determine then if they have something relevant to say. And finally, on the timeline, taking into account the fact that it was a systematically not respected deadline, that there was a justification for the duration, decided that again this breach of the policy is not fatal. So we have a policy with three very particular provisions, all three of whom, well, two of which were breached, and one of which could have been breached. But despite all of that, the arbitrator decided that this was not a case of an unfair policy. The investigation was still reasonable. And so I think the case teaches us two things. One, the good news is a breach of a policy is not necessarily fatal. So policies should not make us blind to the fact that investigations still need to have minimum amount of fair play, still need to proceed in a way that is reasonable. For example, maybe a complaint is not given according to the policy, but a summary of the facts is, it comes down to the same thing. However, the case also teaches us it's rather important not to have a policy that's completely divorced from the operational reality of a business. Policies actually have teeth when it comes to harassment. They create obligations for the employer. They're not a quick fix summary of whatever is in the law. And they create procedural obligations as well. So in drafting those policies, lawyers should be aware of what is their operational reality, having a policy that reflects that reality, but also having a policy that's flexible enough to ensure that the employer is not putting itself, not subjecting itself to impossible obligations. Another case of interest on that fact, this is a 2021 case as well. Same kind of facts. The complaint is suspended with pay for investigation, and then an outside firm was hired to conduct an investigation. The outside firm prepared a report, and following the report, a 3-month disciplinary suspension was posed. A grievance was filed. The interesting thing about this case is that both parties agreed, the union and the employer agreed, that the investigation was covered by privilege. It was litigation privilege, so not attorney-client privilege. So that's another point to consider in drafting policies, but also in conducting investigations, the importance of privilege, whether litigation privilege or attorney-client privilege or other, and the potential waivers of privilege, how employers can act in a manner which tacitly may constitute a waiver of privilege. And a waiver of privilege has a lot of consequences, as you know. The union was alleging that the employer referred so much to the investigation report that it waived privilege over that report. The arbitrator agreed, but made a few distinctions. I think it's worth it just to review those quickly. So, in a suspension letter or termination letter, just referring to the fact that there was an investigation, that it found that harassment occurred, is not a waiver of privilege. However, when the employer here referenced in detail factual findings and statements given to the investigator, so you had a 4-page, single-spacing suspension letter that said, witness 1 alleged that XYZ said this, witness 2 said that, the finding is that. So it pretty much summarizes in detail, though, the investigation report. And on top of that, the employer also produced a section which summarizes the reasoning. It says, considering all of those, we believe this is vexatious conduct. It fits those criteria of harassment, and therefore this constitutes harassment, and this is the sanction I'm imposing. Combination of making yours the reasoning of the investigator and incorporating all those factual findings in such detail into the suspension letter constituted for the arbitrator a waiver of privilege. Now, the thing that saved the employer here is that the arbitrator still found that the report was not relevant. It wasn't relevant to provide the investigation report because that the report does not prove its contents. The content of the report, whether harassment actually occurred or not, still has to be proven before a judge. And I think that's an important point to take away. If you have a policy and you conduct an investigation, maybe the investigation is flawed. That may be an issue if, for example, an employee is saying you didn't investigate enough my allegation, receives proper treatment of the allegation I made. However, when an employer imposes a sanction on an employee, maybe the investigation is not perfect or is perfect, but at the end of the day, the employer must still make proof to the tribunal that the events occurred and that its sanction is justified. So the real investigation, the one that really matters, is the one that also you're going to do before the tribunal, because all of those facts will be proven to the tribunal. An employer cannot simply produce an investigation report and say, here you go, the investigator said so, so it must be so. A tribunal will want to have all that evidence before it. So that's why investigation reports can be protected from disclosure to a certain extent, and there's case law to support. However, what I also take away from this case is the importance of summary reports. Investigators sometimes will produce short version of the investigation report. So one big report, full report, and one short report. The short report is a summary of the allegations, and it's given to the person against whom findings are made. And the usefulness of that is that the employer, in making decisions and drafting documents, can stick to the structure and the content of the report that the employer knows was already given to the person that was the subject of the complaint. So this brings us to a few policy considerations that I end on about harassment. So in drafting policies or in conducting investigations, what are certain considerations that employer can have in mind? So the first thing is the relative importance of fairness. Fairness is important, but at the same time, procedural fairness does not apply to employers by operation of law. So formalistic approaches and investigation policies will only add to the employer's burden. They will only make things more difficult. So yes, for fairness must be a cornerstone of any investigation policy, but at the same time, employers must be aware of flexibility. Overzealousness in drafting the policy is something that an investigator or the employer may regret down the road. The relative importance of confidentiality. Confidentiality is good. Confidentiality allows to avoid a chilling effect. It protects employees from reprisals. It ensures that people will feel comfortable addressing their employer, filing complaints, making whistleblowing complaints, etc. But confidentiality is not a supreme value of itself. Sometimes, if somebody is being accused of something and they must be provided with an opportunity to respond to the allegations against them, that may be inconsistent with full confidentiality. And in those situations, so any confidentiality representations and policies must contain the proper caveats to make sure that people understand that, yes, process is confidential, but a person accused of something must still know what they're being accused of. This brings us to anonymous complaints. Some policies allow anonymous complaints. Question is, how do you deal with those? For example, what do you do if the investigation itself is highly likely to reveal the identity of the complainant? What do you do if you need to gather more facts? A lot of companies that allow anonymous complaints allow them through a process that allows the investigator to contact the person still, but that person remains anonymous, but there's a platform through which they may be contacted. That's one thing. But then again, I've seen it in my practice. Sometimes you have to tell the person who filed the complaint, look, you can be anonymous as much as you want, but the facts are the facts, and an investigation into this will reveal your identity. It's very likely that do so. That's a consideration that policies can address. Finally, timelines. Very nice to want to do things in a diligent manner. Imposing timelines that the employer cannot respect is a whole different thing. So timelines should allow for flexibility. Deadlines should allow for flexibility. Admissibility analysis. This can be structured in a way that makes the process perhaps more efficient, that makes it systematic. We discussed that. The number of individuals present during an interview, company representatives, etc., keeping in mind that declarations make it less strategically important to always have corroborating notes between multiple people at an interview. Identifying stakeholders, who makes decisions, who does the investigator report to, how is the report filed, where do you go to get certain approvals, for example, an expansion of the scope of the mandate, an extension of delays, etc. Investigation reports, privilege or not, how would they be structured? Should they be brief? Should there be requirements for format and structure? And summary of findings. Would summary of findings be produced on a systematic basis by the investigator? It can be useful for an employer when the investigation is done to receive two documents: the investigation report and the summary of findings that would be provided to the person who was deemed to have conducted harassment. That can, again, make it easier to draft letters, make it easier to engage in conversations. The employer would know what exactly is the common facts that everybody is aware of, that both parties are aware of, and can tailor its approach accordingly. So all in all, investigations are a key tool for employers to protect employees, to protect their own managerial decisions against challenge, and to ensure a safe workplace. It's a question of compliance as well. Investigations do need to be structured to avoid the appearance of an arbitrary process. Rules of investigation should not be devised on the fly. But investigations are organic. And even though policies are helpful to structure investigations and processes, and they should be well established, well drafted, well structured, they should also incorporate considerations of flexibility. There can be too much of a good thing. Finding the right balance between ensuring fairness and providing flexibility is one of the challenges and the exercise of drafting harassment policies, designing them, and conducting investigations. So I'll now leave it to Antoine to take you through a few observations about termination of employment.
Thank you, Sharif. So as mentioned in the introduction, I will now talk to you about recent issue and current consideration in termination of employment. So for this part of the presentation, it will be divided between termination for cause and termination without cause. So let's start with termination of employment for cause. The notion of for cause is not defined in the legislation, either in the Act respecting labor standards, whereas the term uses for good and sufficient cause, or in the Civil Code of Quebec, where the term used is for serious reason. It was held that those two terms were similar or synonyms and fell under the definition of for cause. So the definition was therefore developed according to the case law and the doctrine. The Court of Appeal specified in Garneau against Gestion Universitas in 2018 that the notion of serious reason refers to a serious fault committed by the employee in connection with the failure to perform the work provided for in the employment agreement. So, in brief, it is therefore a breach of the employee's obligation that is serious or severe in nature or repeated. Other instances, such as the Superior Court in Tessier against Caisse Desjardins du Centre de la Mauricie, in a recent case, mentioned that for a termination to be for cause or for serious reason, the employee in question has to commit one or more reprehensible acts, which is the definition of the Court of Appeal in Garneau, which, depending on the context in which they were committed, including the importance of the employee's position, have irreparably broken the bond of trust necessary to the relationship between the employer and the employee. So a certain school of thought therefore add the second element to the definition, but not everyone. So termination for cause is in short the exercise of the employer's right to terminate the employment contract of an employee who fails to perform his or her contractual obligation adequately due to inaptitude, misconduct, unwillingness, or incapacity. In determining whether the employee's misconduct constitutes cause for termination, the tribunal takes into account consideration related to the act itself, or the acts if it's repeated, the context in which it was committed and the consequences of it, and the factors related to the employee, such as the role in the company or responsibility in the company. The type of conducts or the type of cause can either be administrative or disciplinary. The essential difference is that disciplinary cause applies to an employee who willfully breached company rules or policies, whereas the administrative cause applies to an employee who unwillingly unable to meet the requirements of their position. Without going into details of both distinction, the distinction is important because it will have a net direct impact on the proof the employer will have to make to establish the cause before a tribunal. The proof to be made is often more demanding for an administrative termination than for a disciplinary termination. The rule of progressive discipline is also something the employer should look at. It is a process where the employers gradually increase the severity of disciplinary action in response to the employee's repeated violation of the workplace policies or rules. The goal of progressive discipline is to correct the behavior rather than immediately resorting to termination. Steps in the process typically include verbal warning, written warning, suspension, and then termination. The process helps ensure that the employee is given fair and reasonable opportunity to improve their behavior, while also allowing the employer to effectively manage any performance or conduct issue within the workplace. However, this theory will not have to be applied when the seriousness of the employee's misconduct is such that immediate termination is required, as it is often the case with death, for example. The rule of proportionality, which is directly related to the rule of progressive discipline, refers to the principle that disciplinary action taken against an employee must be proportional to the severity of the infraction committed. This means that the punishment must be reasonable and appropriate in relation to the wrongdoing. For example, a minor infraction, such as being late, may warrant a verbal warning, while theft, a more serious infraction, may result in termination. The principle of proportionality helps to ensure that the disciplinary action is fair and just and takes into account the specific circumstances of the case. Some things that employers should remember is also that clear policies and procedure in place allow employers to be able to demonstrate that employee was aware of those policies and that they were given the opportunity to improve their behavior before being terminated. Unless, as mentioned before, if the misconduct of the employee is as such that immediate termination is required. It is also important to mention that the case law has affirmed the principle that an employer with just and sufficient cause for termination must generally proceed with the termination within a reasonable period of time after becoming aware of the facts. Failing to do so may prevent the employer from proceeding and having his action overturned or invalidated by a trial. Finally, it is important for the employer to be consistent in the discipline and sanction it imposes to employees, especially employees on the same level, since a tribunal may see this inconsistency as discretionary, and this could be used against the employer in trial. To recall the beginning of the presentation where Sharif talked about investigation in the workplace, it is also happened that termination for cause occur as a result of an investigation. In this situation, it is important to take certain elements into consideration. First of all, the importance of the termination letter. The employer should avoid making extensive reference to the conduct and process of the investigation. It is more important to focus on the facts and the conclusion of the investigation than rather what happens during the investigation. It is not necessary to include exhaustive details or of the investigation that might give the terminated employee additional leverage to file a claim against the company. In addition, the Quebec law does not recognize the concept of after acquired cause. This means that once a reason is provided in the letter of termination, the employer may not, after the fact, invoke independent cause for termination that it failed to raise at the time of the termination. Therefore, the termination letter should be specific enough to be credible, but broad enough to allow more substance to the allegation in the event of a litigation. Secondly, it is important to consider the reputational aspect of the company, of the complainant, of the accused, and everyone else involved in the investigation. The announcement of the dismissal does not have to be a performance where the person is dragged out of the building or from his office in front of all his colleagues. It is important to have a plan for how the announcement will be made not only to the person being terminated, but also how it will be made to the complainant and how it will be made to the rest of the employees. Consideration should also be given to those who have been involved in the investigation anonymously. This is true even if the investigation does not result in a termination. A poorly managed investigation or certain circumstances can sometimes lead to horror stories that could affect the entire company. Let's take, for example, a case law of Syndicat Général des Professeurs de l'Université de Montréal against Université de Montréal, for example. The facts are quite unusual. So Mr. and Madame met for the first time in 1992. The relationship remained strictly professional until 1995, when they had their first sexual encounter on a business trip to Quebec City. Thereafter, they maintained a relationship that is both professional and personal. Their intimate relationship remained essentially secret throughout its duration. Shortly after the end of their relationship, Madame went on a sick leave in 2016. 2 years later, in 2018, Madame disclosed the personal relationship with Mr. first anonymously on January 31st, and then by identifying herself on February 21st, 3 weeks later. On March 6th, the university responds to Madame by email, confirms the receipt of the denunciation letter, and informs her of the next steps in the investigation. Later on the same day, Madame, who is still on leave of absence from work, sends a written statement filed by the police department to an employee of the Harassment Response Office, who is an office in the University of Montreal, and 33 other recipients, including Mr. Sun, who are copied in the email. Essentially, she makes the denunciation public. In her statement, she alleged, among other things, that she was sexually assaulted with bodily harm between 1995 and 2015. She also alleged that Mr. orchestrated a fraud of several thousands of dollars. About a week later, on March 14, the university mandated an external firm to conduct an investigation. On May 1st, Mr. files a complaint of psychological harassment against Madame regarding the denunciation made public. During the investigation, Madame also writes a letter containing comments similar to death threats to Mr., on which the investigation firm will write a second report. As you can imagine, there are several questions that were addressed in this decision, but we will only focus on the two displayed on the screen, which is, was the university negligent in ending Madame's complaint? And is the termination of her employment justified in light of all the circumstances in this case? With respect to the first question, the tribunal held that a delay of just over a month between the receipt of the first denunciation on January 31st, which was anonymous, and the transmission of the complaint to the appropriate authorities does not appear to be exaggerated or cause for reproach to the university. Two elements helped the university for this question. First, it took almost 2 weeks before the university discovered the potential identity of the victim, and 3 weeks before it discovered actual identity of the complainant on February 21st. The other point is that even if the university did not act very quickly, the fact that Madame sent her public denunciation after the university sent her confirmation of receipt of her complaint really helped the university. In fact, the university sent the confirmation on the morning of March 36, and Madame sends the public statement in the evening. With respect to the second question, the tribunal considered the following factors in its assessment of disciplinary measure: the absence of remorse or apology demonstrating a high risk of recidivism, the particular seriousness of the death threat and their violent nature, the fact that the threats were made in writing, demonstrating a certain degree of premeditation, the decision rendered by the Superior Court in which Madame was convicted of criminal harassment and extortion, the use of institutional messaging system for inappropriate purposes, and Madame's resistance to participating in the investigation. The tribunal therefore ruled that Madame's termination was justified despite 18 years of service, her clean disciplinary record, and an isolated nature of her actions. This situation simply demonstrates that it is in the best interest of the employer, as much as possible and when possible, to take action and control to the situation when they receive a complaint so that events do not go out of hands. Now let's talk about termination without cause. As you probably all know, a person terminated without cause is entitled to a notice. The notice period for a terminated employee may be provided in several places, either in the employment contract or in the various law governing employment law. Employees in Quebec who are not senior managers are entitled under the Act respecting labor standard to a minimum statutory notice ranging from 1 to 8 weeks, depending on the employee's years of service. In addition, all non-unionized employees who are party to an undefined term agreement, including this time senior managers, are entitled to reasonable notice of termination pursuant to the Civil Code of Quebec. Reasonable notice will depend on a number of factors, including, among others, employee's age, his length of service, the compensation, his position in the company, and the likelihood of obtaining alternative employment. As a loose rule of thumb, reasonable notice of termination range from 2 to 6 weeks of total compensation per year of service. Total compensation includes benefits, bonus, commissions, and other incentives, up to a rough upper limit of 24 months. The 24 months includes the statutory notice required under the Act respecting labor standards, ranging from 1 to 8 weeks that I talked before. Such notice can be as a working notice, as a payment in year of notice, or a combination of both. Note that in Quebec, an employee cannot waive in advance his or her right to receive reasonable notice in the event of termination without cause. As such, Quebec courts would not be bound by a contractual entitlement provided in an employee's employment agreement to the extent that what is provided is not deemed reasonable in the circumstances at the time of termination. This means that what is stated in the employment contract does not necessarily apply in practice. Further, note that Quebec employees who are not senior manager and who have at least 2 years of uninterrupted services who are terminated without just and sufficient cause can file a complaint under the Act respecting labor standards under Section 124 and seek reinstatement in their position. In particular, this recourse allows the CNSST to, among other orders, order the employee to reinstate the employee with full back pay to the termination date. As for collective dismissal, in addition to the notice that must be provided individually, the employer also needs to provide prior written notice to the Minister of Employment and Social Solidarity in the event where more than 10 employees of the same establishment are terminated or laid off for more than 6 months within a period of 2 consecutive months. It is important to mention that during this period of notice to the minister, which varies between 8 and 16 weeks depending on the number of employees dismissed, the employer must maintain the group insurance and pension plans. The employer cannot decide to pay the value of this plan instead of maintaining them during this period. Now that we did an overview of termination without cause, we wanted to address two current issues. Firstly, a question ranging the dismissal of people who have access to disability benefits, and secondly, current consideration in the current market and economy. A recent Court of Appeal decision, which is Caisse Desjardins de Raymond Sainte-Catherine contre Girard, has provided insight into a question frequently asked by employer, which is the following question. Can the indemnity in lieu of notice be deducted by an amount equal to the disability benefits received by the employee during this time, based on the ground that the employer took part in the financing of the insurance scheme? The facts of this decision are relatively simple. The employee was appointed manager at Caisse Desjardins Populaire de Saint-Raymond-Sainte-Catherine on April 25, 2013. Approximately 1 year later, the employee had a major altercation with the employer's general manager. In the days that follow, the employee sank into depression and will receive disability benefits for a period of 28 months, so just over 2 years. During this period, she will receive a letter terminating her employment effective February 16, 2015. She then started a new, lower-paying job in a different industry. The Superior Court, so the trial judge, determined that the disability benefits received should be deducted from the indemnity to compensate the employer's contribution in financing the insurance scheme. So he answered yes to the question. The trial judge determined that an amount of $73,476 should be deducted from the indemnity in lieu of notice. The Court of Appeal is of the opinion that Article 1608 of the CCQ applies whenever an employee receives disability benefits from an insurer, regardless of whether the employee pays all or part of the cost of the insurance premium. So 1608 of the CCQ reads as follows. The obligation of the debtor to pay damages to the creditor is neither reduced nor altered by the fact that the creditor received benefits from a third person as a result of the injury he has suffered, except so far as the third person is subrogated to the rights of the creditors. In other words, the fact that the employer pays all or part of the cost of the premium has no effect on its obligation to pay damages when the indemnity in lieu of notice is insufficient. Referring to the comments made by the Minister of Justice at the time of the adoption of the CCQ, the Court of Appeal stated that even though this solution may result in a form of double indemnity, since the insurer is paying and the employer is paying, the solution chosen by the legislator, it is the solution chosen by the legislator for Article 1608. In conclusion, the Court of Appeal held that the disability benefits paid by the insurer should not be deducted. Employers should note that their participation in financing an insurance scheme will not allow them to deduct this amount from the termination notice. The payment in premium does not affect the employer's obligation to pay damages when the notice of termination is insufficient. However, the Court of Appeal mentioned that it would be different if the employer paid the salary or part of the salary instead of insurance premiums, since in this case, Article 1608 would not apply. Now let's talk about consideration in the current economy. We're seeing two things right now. First, employment is still relatively high, So there's still a lot of people getting some jobs. But on the other end, we're looking at perhaps more challenging time ahead. Therefore, employers could use the current market of high employment demand to their advantage when negotiating packages with employees so that they can pressure the employee to mitigate their damages. As for example, the employer can consider giving career transition services as part of a package, and where agreement on a package is difficult to reach, consider giving the service anyway without an obligation to sign a release, as this would put pressure on the employee to mitigate the damages. If a tribunal finds that an employee had the tools to find a new job and did not use it to his advantage, it will backfire on the employee, or it could. This would also help for collective dismissal requirements. Providing career transition service directly to the employees can lessen the burden with the government, since the government won't ask for contribution to a jointly determined career transition service if the employer is proactive in this regard. Another consideration is negotiation in the collective dismissal context. Employers need to be vigilant with employee counsel who will be on the lookout for collective dismissal in an unknown economy right now, and will contact employees to try and generate cases. This could become a line of business, and employers should be aware that more employees could come challenge their reasonable notice. Employers should also be careful of setting precedent in negotiation and negotiating packages before the bulk of termination are effected, because you can't be stuck with what you said on the first place. This can be an issue majorly in multi-phase collective dismissal. So finally, given the current uncertain economy, we thought it would be appropriate to talk to you about collective dismissal, since maybe probably few of you have noticed that in the last few weeks, several collective dismissal have been announced, mainly in the tech industry. In this regard, employers could prepare a list as shown on the screen with responsibility and dates for each task. Since several people are usually involved in the collective dismissal, a checklist is always convenient to be more prepared. The list on the screen is not exhaustive, but it is nonetheless a good starting point for tasks that needs to be done. First, it is important to determine the date of the announcement to the employee and the minister, depending on the number of employees being laid off or terminated with the law, to comply with the law. Then, it is important to do a reasonable notice assessment exercise to evaluate what each employee would be entitled to as a notice of termination. It is also at this time that the employer should determine whether it wants to give working notice, payment in year of notice, or a combination of both. In the event of a progressive collective dismissal, it is also important to identify the people who will be staying with the company for a longer period of time to ensure that the transition or the closure of the company is effective. It is also important to identify the key employees who will have important tasks, such as who will know in advance the news, who will have to break the news to other employees, and who will be the one chosen to stay on if applicable. Other important step would be to talk to external parties, such as the company benefit provider, a PR firm if needed, or a career transition service organization, as discussed earlier. Documents such as notice to the minister, the notice to employees, and a Q&A to answer questions from employees if needed, termination letters and packages will need to be prepared. Finally, it will be important to schedule individual interviews with each employee to explain what is being offered to them and have them sign a release. So now would be time for the questions. Microphone is.
Yes. Okay. Concerning this case of Caisse Populaire, okay, I find that, I don't know, I am asking you, do you find the conclusion of the Court of Appeal well-founded because it comes in contradiction with the basic insurance law principles that you cannot have double indemnization. In insurance law, that's a basic principle. So I am not comfortable with this conclusion because there is, in fact, double indemnization and it comes in contradiction with the basic insurance law principle. I would like your opinion on it.
That's a fair point. I mean, this issue has been debated for a long time. It goes back to the Sylvester case of the Supreme Court of Canada, and there were multiple cases after. I find that the Court of Appeal case does pretty much settle the issue. And the logic of saying there is no double indemnity here is that a reasonable notice serves the purpose of allowing a person to find another job. Disability benefits serve the purpose of paying somebody who is unable to work. You cannot both be unable to work and find a job. By definition, there is no double indemnity. That's how the syllogism would go. Do I agree with it or not? It's the Grand Manitou a parlé. The Court of Appeal has spoken, but I see your point. But I do believe the courts. It's a complex case. It's very well reasoned. Well, it's extensively reasoned. So I think it does settle the debate. We'll see. But a lot of us did have a certain reaction when we read the case. I wouldn't. I'll give you that. I see a few questions about logistics. Catherine, we will send you, I think, all the information on that front. Thank you all. Thank you for listening.